Okay, next heading is legality of object and consideration. Section 23. As per section 23, they have given few cases where consideration or the object is said to be unlawful. Okay. First one. I started, mama. Okay. The first thing is, if it is forbidden by law, what should I do? Okay. Example of a law which is forbidden. I have given example, child marriage. Second one, defeating the provisions of law. All same only. If the purpose of the contract, whatever you've entered into, is not legal, not lawful, then again it will be unlawful. Third one, fraudulent. All the agreements or contracts which are entered to defraud a particular person or defraud a particular entity, it is void. Next, involves injury to a person or a property. Involves injury to a person or a property. Injury means harming someone wrongfully. Again, the purpose is wrong, so it is void. Example, intellectual property rights. So someone else's material, you take it. Registered, they have registered license, even after that you take it. Xerox, taking Xerox of books. All this is not legal. Next, there are few given under opposed to public policy. Some agreements are held to be opposed to public policy. First one, trading with enemy country. I've given example, TikTok. So TikTok is banned? Yes. Second one, trafficking of public offices and titles. Trafficking means?
Racket blocking.
What racket block?
Somewhat of doing illegal.
Okay, so what is here? Trafficking of public policies,
Having
offices and
information
titles.
about
Trafficking means sale. Sale. Office is vacant. A position is vacant. I will make you join, provided you give me 5 lakhs. Titles. Padma Bhushan, Vibhushan, all those are not sold. I'm just telling an example. Those titles are not sold. If at all a person is giving you money to give the title, it is void. Clear? Agreements creating monopoly. Agreements creating monopoly. Two firms join together and try to control the prices. Those agreements are not valid. Void agreements, opposed to public policy. Marriage brokerage agreement. Marriage brokerage agreement. You give me 5 lakhs. I will increase your name, fame, worth. I will spread false information about you and get you a person to marry you. This is called marriage brokerage agreements. That shadi.com and all is there, no? That is valid. Why? Because whatever information you have given to them, only that they display. They don't add on to it and they don't provide information. Clear? But marriage brokerage contracts or agreements do that. Next one, interest against obligation. Now, in that, there is one example. See, A, who is the manager of a firm, agrees to pass a contract to X. If X pays to A 2 lakhs privately, the agreement is void. I am working in a particular firm. I am not supposed to leak out information of this firm to another person. If you do so, that is void. Consideration unlawful in part. Here also. For example, I hire a Zoom car. No, not I. Mr. A hires a Zoom car. Zoom car, you know, they take it on rent for the whole day. Okay. A has paid 5,000 for that particular car. Why he is taking the car? Then he calls his friend Mr. B and both of them go and kidnap C's son. C's son. There are 2 contracts here. One is the contract of hiring car and next is kidnapping the son. They kidnap the son and put it in that car. Who will be held liable? There are 2 contracts. It is unlawful in part. Kidnapping of son and putting it in the car is unlawful, but hiring the car is lawful. Will at any point of time that Zoom car person will be liable? Because he didn't even know that why the car is getting used. Hiring of car is allowed, valid, legal. For that 5,000 is received, that is also legal. But he didn't know that further subsequently it will be used for unlawful purpose. So the first part is valid. Second part is void. Next, stifling prosecution. Stifling prosecution. Stifling means stopping. Prosecution means court proceedings. So if you bribe someone that please do not file a case, or whatever case proceedings are going on, you take so much money and shut down. That is called stifling prosecution, which is void, not allowed. Next is maintenance and champerty. Now supposing there is Mr. A. He is not having sufficient money. He has been cheated by, tell me a big name. Hindustan Unilever. Hindustan Unilever, this company's manager has cheated this Mr. A. But this A is very poor. He does not have sufficient money. There is another person, C. C tells that, you don't worry, both are friends. I will give you money. You file a suit against HUL and claim your compensation. I will give you money. Is C having any interest? No. It was between A and HUL's manager. C is having any interest? No. Just because he is a friend, he is just giving monetary help. This contract is called maintenance. This contract is called maintenance. Here C may get something in return, may not get something in return. He can tell that If you win the case and if you're given compensation, 10% of that you get. May get in return, may not get in return. This is called maintenance. Next is Shamperty. Same thing. In Shamperty, C will get return. C will get return. Now this type of cases, who will enter into is lawyers. Mostly lawyers will tell to their clients that I will make you win the case. Whatever property or assets, whatever compensation you get, in that 20% you have to give. That is called Shamperty. Is it valid? We are studying what? Agreements which are opposed, where the consideration is opposed to public policy. So is it valid? It is not valid. Both Shamperty and maintenance are not valid. You are a third party, you have no interest in the contract. Even after that, you are giving some financial help. That means there is some quarrel between you and that company, HUL, between C and that company, HUL. That is possible. That you are trying to take it out from A. But such contracts, maintenance and Shamperty, are not valid, void. This came, I think, some 2 attempts back it came, this question. Shamperty and maintenance. Next is agreements expressly declared to be void. Agreements expressly declared to be void. First one, agreement entered into by incompetent parties. So all the three, major, sound mind, disqualified, is not satisfied, it is void. Second one, bilateral mistake of fact. Again, it is void. Both the parties are not aware of the terms and conditions or wrongly mistaken. Void. Third one, consideration of the object is unlawful. It is void. Unlawful in part, the illegal part is void. Agreement made without consideration is void, excepting the few exceptions. Sixth one, agreement and restraint of marriage. To stop a particular marriage, not allowing a particular person to get married to someone. That is void. Agreement and restraint of trade. Agreement and restraint of trade. Restraint means stopping. So you give a consideration to make sure that that particular person do not do business. That is void. Agreement and restraint of legal proceedings. You stop a particular person that do not file a case. Void. Agreement, the meaning of which is uncertain. The terms are not certain. Confusing. Oil, which oil? Car, which car? That is void. Wagering agreement. Now, what do you mean by wagering agreement? Wagering means what? Wagering means I will pay you some money if a particular event may happen, may not happen. So this wagering agreement is dependent on a particular uncertain event. Clear? Such wagering agreements are void. Do they have any interest in that particular event? Supposing, best example is the cricket match. Australia versus India. Okay, Australia versus India. No, yeah, in that match we will have some interest, no, that our country has to win. We will keep, yes, Australia
Zimbabwe versus Netherlands.
Okay, Zimbabwe versus Netherlands. Both two different countries. We are least bothered who's going to win. I am telling Zimbabwe win. B is telling Netherlands win. We are not bothered about the match. We are bothered about our win and our loss. This is called wagering agreement. Clear? Whether it is valid? Wagering agreements, void. Lottery transaction. Lottery transaction is valid? Void. As per Indian Contract Act, lottery transactions are void. Where it is valid? Somewhere in Kerala. Kerala lottery transaction is valid, but whenever if they ask you question and exam, you're supposed to write void. Next, crossword puzzle and competition. So because it involves skill, personal skill, crossword puzzles and competition, there is an amount, 1000 rupees set. Up to 1000 rupees the prize money, it is valid. Beyond 1000 money, it is 1000 rupees, it is void. Clear? Even crossword puzzles and other competitions. Horse race transaction. In horse race transaction, if the amount is less than 500, it is void. Opposite. Crosswords and horse race are opposite. Crossword, I told you, lower amount, 1000 rupees, valid. Higher amount, void. But horse race, higher amount is valid. Okay, this is a very old provision which they have not even changed. Previously, rich people used to go and do this horse races, correct? So, higher amount was treated to be valid. It was not void. Up to here, whatever we saw was void. Wagering agreements which are void. Lottery, crossword puzzles and competition. You have to mention 1000 rupees, it's valid. More than 1000, it's invalid. Horse race transactions, less than 500, it's invalid. 500 and above, it's valid. Then now we are going to see transactions which are similar to wager but are not void. Chit fund. All the chit fund companies you see, no, it is valid. It is valid. Commercial transactions, share market transactions. Now, share market is also completely wagering only. We are betting, price will increase, price will decrease. But it is legal, lawful. It is wagering only, but it is lawful. Game of skill and athletic competition, again, it is a competition, skill is involved. Again, 1000 rupees is the limit. More than 1000, again invalid. Insurance contract, valid. It is contingent, it is depending upon an uncertain event, but it is valid. How is contract of insurance different from wagering? How is contract of insurance is also, we will pay money or money is worth depending upon an uncertain event which may or may not happen. Life insurance contract, death may or may not happen. Whenever death happens, I will give you money. But how is it different? Contract of insurance is valid, but the normal wagering agreement is invalid. How? Is there any interest in the insurance policy? Yes. Life of the particular person, there is interest. But in case of wagering agreement, that particular match, are you interested? No. Whichever country wins, who knows? Let them win, let them lose. Understood? Clear? The wagering can be a question mark. Transactions which are, what is wagering agreement? Transactions which are valid under wagering agreement, transactions which are void under wagering agreement. This unit is done. So we successfully finished 3 units in not more than 2 hours. Fourth unit, performance of a contract. Now in this performance of a contract, there are 2 types of performance. Actual performance and attempted performance. Actual performance is on the date of performance, the parties actually perform their obligations. Whatever date they have agreed, I will deliver 100 kg of sugar to B. A actually delivers it on that particular day. That means it is actual performance. Attempted performance. Attempted performance. A is ready to deliver 100 kg of sugar to B on 8th December. But B tells that, no, you don't deliver. It is holiday. Nobody is there. This is attempted performance. I tried, but B refused to take the delivery. Refused to accept the performance. Now, what will be the effect of this? If in case of attempted performance, B refused the delivery. The agreed date was 8th. Why you didn't know before that 8th will be holiday? It is not my mistake. What I can do? Again, I cannot deliver. I can put an end to a contract. A can put an end to the contract. Who has to perform? Who may perform the contract? First one, self, promiser himself. If it involves personal skill, then that particular person only has to perform. Second is legal representatives. If that particular person dies, his legal representatives can take over if it does not involve personal skill. Clear? If it does not involve personal skill. Agent. Again, if personal skill is not required, you can appoint an agent to work on your behalf. Fourth one, third person. Third person. Now, what is this third person is? Supposing there is Mr. A. He has been appointed by a restaurant. He is a singer. He has been appointed by a restaurant to sing on Sunday, 8th December. Some light music. The background music will go on. No? So instead of that, this person is going to sing live. This person on 8th morning, he informs that I will not be able to come. My friend Mr. B is also a singer. He will come. He is a third person. In this, it will not matter whether it is Mr. A or Mr. B. Did we announce who is going to sing? Had it been a very famous personality, it will matter. Concert cancelled because that particular person is not able to perform. Can we replace him? No. In that case, it will not be replaced. But here, can it be replaced? Yes. So, B is a third person. Clear? If the restaurant agrees, B can go and sing. All the terms and conditions remaining the same. Joint promiser. All the persons have to jointly perform the contract. Joint promiser. Next, rules relating to joint promiser. If you want 2 minutes, you can go through more. Where are you? Stop. That legality of object and consideration from there till here. Wagering alone, I didn't complete fully. I forgot. No? finished? Next, rules as to joint promisor. In case of joint promisor, who has to perform the promise? Any of the joint promisor can do? Yes. Supposing if it involves payment. Okay, there are some 4 people, A, B, C, D. Only A has paid 2 lakhs. They have to pay to Mr. E. So can A recover it from B, C, D? A has individually paid 2 lakh to Mr. E. Can A recover it back from B, C, D? Yes. Because all the 4 of them were jointly responsible to make the payment. But because A has temporarily paid, he can recover it back from B, C, D. A, B, C, D. Okay. A died. So the contract is continuing between B, C, D only? No. B, C, D and A's legal representative also. Clear? Next. Rules of joint promisee. Again, all the joint promisees together have the right to claim performance. If one of the promisees die, the legal representative of that promisee along with other surviving promisees can continue claiming the performance. Clear? Next is time and place for performance of promise. Now, if time is not specified, place is not specified. Both are not specified. What will happen? When if the promisor has to deliver the goods to a particular place and time, how will the agreement continue? If A has to deliver 100 kg of sugar to B on 8th December, time is not mentioned, place is not mentioned. What will he do? He will call and ask, okay, where I have to deliver, which place I have to deliver. He will say, my go down. When? Within reasonable time. If it is 100 kg of sugar, maybe within 1 week. Clear? If it is 500 kg of sugar, maybe within 2 weeks. So reasonable time depends upon the nature of contract. Case 2, both time and place are specified. Both time and place are specified. Is there anything else to be done? No. The promisor have to perform the promise on the stated place and in the stated time. Next, both time and place are not specified. Promisee will call and request the promisor that you can deliver it on a particular place and a particular time. Application by the promisee. First point, if you see, time for performance of promise where no application is to be made and no time is specified. So, no time is specified, no place is specified. Promisor will have to call up and ask promisee where I have to deliver. Second, both time and place are specified. Then on the agreed time and date. Next heading is reciprocal promise. Reciprocal promise means A and B doing their respective obligations or performing their respective promises are known as reciprocal promises. First one, promisor not bound to perform unless the reciprocal promisee is ready to perform. A appoints B to construct a house. A appoints B to construct a house. B tells that only if you give me an advance of 50,000, I will construct. B tells only if you give me 50,000 advance, I will construct. So A accordingly have to give 50,000 only, then B will perform the promise. Second one, when one fails to perform the promise, he cannot compel the other party to perform and claim compensation. After A has appointed B, given an advance of 50,000, given an advance of 50,000. Till 2 months, he didn't even start to work. Time allotted was 3 months. Till 2 months, he didn't even start to work. Can A file a case against B? He have to max wait till 3 months and then he can file a case against B and claim compensation. Clear? On that date, after 3 months, if he appoints another person, another contractor C, at what price C is quoting, supposing C is quoting 80,000, the difference 30,000 he can claim from B. Next, order of reciprocal promises, performance. Now, so this will vary based on each contract. Supposing you go to a restaurant. What you do usually in restaurant? You will eat and then only pay. Correct? There are few hotels where you have to pay, block the seat and then eat. Pay, block the seat and then eat. Entry 5,000. You may not even eat for 5,000, but you will have to pay 5,000, block it and then go in. Clear? So order of performance depends upon the nature of the contract. Reciprocal promises which are legal in part. Reciprocal promises which are legal in part, if separable, then valid part is enforceable. A agrees to sell 100 kg of sugar. B gives, supposing 50 rupees. For 5,000, 2,000 rupees he gives cash, 3,000 rupees he gives some drugs. These are reciprocal promises. 2,000 is valid, 3,000 is invalid. Clear? Void. Feeling sleepy? I want to complete at least some 6 units. Huh? Slept off a nice story I'm telling.
That open.
It's okay to that. What to do? Subject is like that.
Recording picture.
Proof.
2020.
Next, impossible act. There are 2 types of impossibility. Initial impossibility, supervening impossibility. In initial impossibility, from the beginning, that example of death, A and B. A delivers 100 kg of sugar, agrees to deliver at 50 rupees, but that factory gets destroyed. Both the parties did not know. So that is initial impossibility. The contract turns to be void. Supervening impossibility, subsequently happening. Initially it will be valid and subsequently it will turn void. Clear? Next is effect of failure to perform. Supposing the goods have to be delivered on 10th December. Now there are 2 possibilities. You deliver on 10th December because I have to deliver further to my particular customer. It's okay, you don't deliver on 10th December. You deliver it by 15th also, no problem. Here there is no commitment to further deliver. So time is not essential. On 10th December, time is essential. Because I have further agreed to a particular customer. So time becomes essential. Here I have not agreed. So time is not essential. So where the time is essential, I can claim compensation. Because I lost a particular customer, you will only have to give me compensation. Where the time is not essential, it depends on the particular party. If you want, you can give extension. If you want, இன்னைக்கு தான் வேணும் நீ குடுக்கலனா you will have to give me the difference. Clear? So time is not essential, it depends upon the party. Okay, 2 minutes I'll give you. Just read the heading of reciprocal promises.
Break.
Hey,
Everyone will be refreshed.
no.
Power nap.
30.
That is not power nap. That is sleeping.
Okay, sleeping. Finished? Next heading is appropriation of payment. What do you mean by appropriation of payment? What is appropriation of payment, ma? Two people A, B. Continuously A is purchasing from B. What?
I'm telling you.
Tell.
Adjusting.
Continuously A is purchasing from B. First he purchased for 50,000, then he purchased for 20,000, then he purchased for 70,000. Clear? Now A has to make the payment. After 6 months, he is making one payment amounting to 60,000. Amounting to 60,000. If A has specified, see the 60,000, what you do? You allocate it towards the first bill and the remaining you allocate it towards the second bill. A has specified, then accordingly it has to be done. Quite possible that A does not specify, then where to do? It depends upon B. It depends upon B. Instead of 50,000, if it is, instead of 60, if it is 50,000, the exact amount of one bill. The exact amount of one bill. It means A has given an implication, A has implied, A has indicated that this 50,000 has to be adjusted towards the first bill. Similarly, had it been 70,000, it implies that it is towards third bill. It cannot be adjusted towards first and second. Understood? Clear? So expressly also A can specify. Implied also he can indicate also that this amount is towards this bill. Both the things A has not done, B will follow first in, first out, 3, 4 in the order of date. The earliest will be adjusted first. Clear? Next heading. Contracts which need not be performed. Contracts which need not be performed. First one, novation. Novation. Novation means old contract is discharged and a new contract is entered. That is called novation. Next, rescission. Rescission means cancellation. Rescission means cancellation of the existing contract. Alteration. Alteration. Changing the terms and conditions of a contract. Alteration. Remission. Remission. Waiver. Venkat Shastri has taken 1,000 crore loan from PNB Bank. How much? 1,000 crore. 10,000 crore. He is telling that I have only 6,000 crore. If you want, you take. Otherwise, go. This also I will not.
Then give me 6,000.
Banks accept 6,000. And remaining 4,000, what did they do? Remitted, waived. Okay, don't pay, go. Clear? Understood? Who did this?
Bhaskar years.
Practically, someone has done this. Who?
9,000 crores.
Vijay Mallya, 9,000 crore. 5,000 he paid, 4,000 he didn't pay. Next heading, discharge of a contract. Last heading of this unit. So how a contract will be treated as discharged? Firstly, by performance. By performance, a contract can be treated as discharged. Secondly, lapse of time. If you don't perform it within the specified time period, the contract will be treated as discharged. No obligation further. Third one, impossibility of performance. Contract requiring personal skill, person itself dead, person insolvent. No need to perform. Contract was valid when it was entered, then there is a change in law. Again, impossible to perform. Next, operation of law. Operation of law is nothing but death, insolvency, conviction. Next, breach of contract. So if there is a breach by any of the parties, the other party will be discharged. A to deliver goods on 12th December. He did not deliver on 12th December, he is delivering on 14th December. What can B tell? You didn't read the terms. Go check your agreement and come. It was 12th December, you can go home. I don't want the goods, I will not pay also. Breach. Last one, merger of rights. Merger of rights, best example is tenancy plus ownership. Supposing I am staying in a flat. Okay, I am a tenant there. I am paying 50,000 per month. Next month, I pay the whole amount for the flat and I become the owner. I become the owner. Will the 50,000 per month I will be continued to liable for that? No. Because these two rights have merged and the superior right prevails. Clear? The agreement automatically comes to an end. Tenancy agreement automatically comes to an end. We have successfully finished fourth unit. You can just go through the last two topics. Appropriation, contracts which need not be performed, and discharge.